In this segment, we're going to talk about renters' rights and remedies under the Utah State Fit Premises Act. If a renter has a landlord that is not fulfilling their agreement or violating their contract or has a habitability issue, the state law gives you certain rights and remedies. I need to start right off the bat saying you're not entitled to any of the remedies we're going to teach you unless you're current on all charges. So the number one rule is, in order to exercise your rights and remedies, you must be current on all your charges. You can't use one of these issues as an excuse to not pay rent. Rent in Utah is required to be paid regardless of if everything is perfect or not. So pay that first and then go through this process second. So in Utah, we have a State Premises Act that defines habitability issues and says they need to be remedied within 3 days. It also defines contract issues. That's anything else agreed to in the contract. And that needs to be fixed within 10 days. I'm going to throw up a couple of notices here. The first notice is the 3-day deficient condition notice. It says that the landlord must fix the following condition within 3 days, and then it allows you to opt for one of the two remedies, which I'll go over in a second. Next, I'm going to show you the 10-day deficient condition notice. It's almost exactly the same, except as you can tell, this is for different issues. Habitability issues are things like water and sewer that aren't connected, electrical, or that aren't connected or working, electrical that's not working, heat and hot water not being available, doors and windows that don't secure, and air conditioning that doesn't work. Everything else, like a broken refrigerator, the garage door, a leaky roof, something like that, those are the 10-day issues. So you need to know which issue for which form and use the right form. I'm also going to throw up a form. There's a 24-hour notice, and this is only for issues that are so dangerous that if not begun, repairs within 24 hours could have serious health and safety ramifications on a renter. These would be things like electrical that's hanging and could electrocute somebody, or raw sewage currently backing up, or something like that that is just so dangerous that it needs to be started repairs within 24 hours. Doesn't need to be fixed within 24 hours, but repairs need to be started within 24 hours. So let's talk about the two potential remedies. On those forms, they say that if the landlord doesn't correct it within the required period, a renter might take one of the following options. The first option is rent abatement. This is where a renter can cancel your lease. So if you're on a year's lease, your furnace is not working, and your landlord refuses to fix it after you have properly notified them and waited the required number of days, you can, at that point, under the Fit Premises Act, get out of your lease. The landlord is required to refund your full deposit plus any prepaid rent, and you can go to court to enforce that if you don't get that immediately when you move. The second option is the repair and deduct option. Now, this is an interesting one. Many landlords and many tenants wonder if tenants have the right to just fix something and take it out of the lease. And the answer is absolutely, they never have the right to do that unless the landlord allows it, or unless it's a result of failure to comply with the deficient condition notice. And then at that point, after they've waited the required number of days and properly notified the landlord, the tenant can repair and deduct an issue. So let's take the furnace again. Say the furnace costs $1,800 to replace. It's $1,000 rent. If your rent is paid up for April, and you then say, well, I served them properly, didn't fix it, I'm going to purchase a furnace myself and have it installed. It's $1,800. You can pay that $1,800 and then deduct it from $1,000 from May's rent and $800 from June's rent. You have the right under the law to do that. So those are the two potential remedies. Now, how do you serve these notices? Landlords and tenants are under the same guidelines as far as serving notices. There's 4 normally, but in this case, the Fit Premises Act also gives a fifth. It says any way the landlord allows in their lease. So if your landlord in your lease allows you to email or you to text or you to do any other way to notify them, you can notify them that way. But the 4 ways in the statute for both landlords and tenants to serve each other when there are issues are: 1, knock on the door of the business or the home and serve the tenant or the landlord personally. Number 2 is, after failing to find someone at that address, post it on the doors. Face out, all 4 corners taped. That's how we recommend. 3rd is you could serve it certified mail. In many cases, people don't always pick these up, and so it's not considered served unless it's picked up. So if the only thing that you have is an address, like a P.O. box or something like that, then you can serve it certified mail, but it would probably be better to serve another address or have another way in your lease, like email or something, that you could notify the landlord. Then last is you can serve another person at the office or the premises of the landlord or the tenant who is of suitable age and discretion. Courts generally consider that to be 16 years and older. This is almost never done because if there's a babysitter or there's just the receptionist, not the person that you need to serve, you can just post it to the door because you failed to find someone there. So those are the ways that you can serve. These are the rights and remedies under the Fit Premises Act. Hope this has been helpful. There's some great training for both landlords and tenants through the Apartment Association. If you have any other questions, try that training or contact us. Thank you.